Alright everyone, we start off today talking a little bit about the Rittenhouse trial. Of course, I've said before, I find it difficult to believe that he's going to be found guilty, at least on the major charges. Now, the other day, the judge is allowing them to consider the possibility of Rittenhouse as an aggressor, that is, provoking the initial attack against him. If that's the case, at least in that context, then he couldn't argue self-defense. I have a feeling, I'm finding it hard to believe that you can find 12 people that wouldn't look at that video and say he was being chased, he was being threatened quite clearly by an individual while unarmed, did not initially shoot him, attempted to ward him off otherwise, ended up not able to actually flee from him, couldn't go fast enough, and was attacked. So, but we'll get past that because it has nothing to do with this particular subject. What this subject is, I'm seeing the same fallacy over and over and over and over again, posited by people who don't like Rittenhouse. And let's be clear, most of the people that think Rittenhouse is evil or murderous or whatever, they are doing that for political reasons. Most of them, by the way, not even by choice. They've just been brainwashed by CNN, MSNBC, etc., which, much like with the Covington kids, although that encounter doesn't involve killing people, and told stories initially in the wake of the Kenosha shootings that were clearly not true. They maintained for weeks that Rittenhouse had trafficked a gun, predominantly going there to take part in paramilitary activities. We now know that to be false. But the biggest fallacy I see is the idea that he was breaking the law, and therefore it's impossible, assuming he was breaking the law at the time that he acted, for him to defend himself. Wondering why that logic is not applied to Rosenbaum and Grossenkreutz, but, you know, they're on the left, so they think that Antifa members are good people. But keep in mind down below, first and foremost, if you're watching this video on YouTube, there will be a pinned comment with links to 4 other video hosting sites that I use. Keep in mind, I make several exclusive videos a day. Again, not sure I'll get to the extra video, although there is a literary update, so I've got a huge amount of material to do. I will be getting back on Daily Motion as well, but I'm going to put off that announcement because I've got too many videos. I've got a backlog at the moment. Here's the problem with saying you're not allowed to defend yourself or use self-defense as a legal claim if you are in the commission of any other form of crime. Jaywalking is a crime. Let's say that I'm jaywalking and someone comes along and shoots me in the head, and their defense in court is something to the tune of, well, you know, I felt threatened by this person and they can't defend themselves because they're breaking the law. Let's say, for example, you're speeding and another motorist starts attacking you or rams into your vehicle trying to run you off the road. Does that preclude your ability to defend yourself in that situation through whatever means you feel necessary? Are you disallowed to do anything other than speed even more in order to flee, which Kyle Rittenhouse sort of tried to do and failed, and that's why the first dude was shot in the first place? What happens is you get into a really, really dubious situation. Let's say that I'm unknowingly trespassing on someone's property. Specifically, I'm not doing anything else wrong. I happen to be, 2 feet off of the sidewalk. I'm not even aware of that. And someone comes out and starts screaming at me and punching me. If I punch that person back, am I guilty of assault simply because I unknowingly trespassed? In some states you have, of course, castle doctrine, not always going to apply in such a situation. The idea that Rittenhouse can't defend himself against multiple assailants would also have to, therefore, necessarily apply to the people that were attacking him, one of which quite literally is invoking the concept of self-defense. Well, he was an active shooter at the time, so I pulled out my gun to stop the active shooter. Well, you were there illegally. You also illegally were carrying a firearm. I'm surprised that nobody points this out in the legacy media. So you couldn't defend yourself either. You were taking part in a riot. And supposedly after curfew, although that charge was dropped for Rittenhouse, and I'm not sure what pertinence that even had to the case to begin with. And anyway, I find it also a little bit funny. This is a semi-related topic, how a lot of people are saying, well, Rittenhouse is done for. The jury's allowed to consider whether he provoked these people. The jury will be hearing the final arguments from the defense and the prosecution, and the defense is going to point out, and this is clear, watch the fucking videos, and it's quite clear, Kyle Rittenhouse, admittedly, this was admitted to by Grossenkreutz, never did jack until he had already had a gun aimed at him. If you have a gun aimed at you, even if you yourself are armed, and you try to flee after having done nothing else specifically wrong other than maybe having a weapon while underage, and again, even that charge is dubious because there are exceptions involved for 16 and 17-year-olds in the state of Wisconsin, specifically involving rifles. Up in the air, I would say, too, as to whether that would even stick. You're saying, quite explicitly, that he never did anything until a gun was pointed at him. He then turned around and attempted to flee. He was unsuccessful, shot the first dude. He then gets attacked by several other people, shoots them, kills one of them. That's what happened. We've got it all on video. The enhanced drone footage, I don't think, is going to change the minds of the jury. I actually support the decision, though. The idea that you can instruct the jury that they're not allowed to consider the possibility that Kyle Rittenhouse provoked anything would preclude him from being found guilty on any charge, and you might as well not have a trial to begin with. Now, we may support that, but once the trial has actually begun, the jury has to be able to consider that fact. I don't think that they'll find him guilty. It maybe slightly raises the odds of certain charges, but again, how can you even conceive of a murder one when the individual who shot the man clearly was fleeing and didn't have time to lay out a plan for premeditated murder? I don't even know why they sought it in the first place. I guess just so they could get all the lesser includeds and so they could have all their bases covered. Anyway, the idea that Rittenhouse, and I deny this, he was not breaking the law at the time, he just defended himself. But even if he did, he's violating curfew, he has an improper gun, he's walking in the street, he is jaywalking half the time like everyone else was. There's a riot going on. Well, he's there. It's an unlawful assembly. You could construe it as him taking part in unlawful assembly. That doesn't mean that situationally within that larger context, a person can't attack you and you defend yourself. It's not the way that the law works. As far as I know, there's no state in the Union which would have any state law that would preclude you from defending yourself. I do find it funny, pertinent to riots and totally unrelated. Do you remember when people had the Guy Fawkes masks in New York and New York City quickly banned wearing masks during protests? Well, it's funny. Now you have to wear a mask during the protest. Very, very interesting. It's a huge fallacy. I don't expect Rittenhouse to have the book thrown at him. Some people are like black pilled. I remember Kate Law was covering it last night, and they're like, oh, it's so important for them to keep the provocation thing out of admittance, and now Rittenhouse might be screwed. Maybe, but again, and the other problem is this: if the judge hadn't allowed that, you'd probably have riots right now. The leftoids, I hate to argue pragmatism. I know this isn't supposed to be what happens. SCOTUS does this. They're not technically supposed to take a temperature of the public and say, well, this is we know it's constitutional, but it'd be so unpopular that we're going to block it. They're not supposed to do that. But they do weigh pragmatism and then hope that the states pick, like with gay marriage. Gay marriage clearly would be constitutional. Clearly the state contract can't be denied legally consenting adults, U.S. citizens, law-abiding individuals. But they held off for years and years, even taking the case, despite supposedly they need to, because people are being deprived of equal protection under the law, but they very wisely waited for the preponderance of states and public opinion to move in the other direction. They probably figured it was going to happen, and they were correct. It was 10 years belated, but they were correct in doing that. They would have caused huge problems and probably backlash had they not. I have a feeling that that's why the judge is allowing that preponderance. I also don't think the judge expects him to be found guilty. And even if he is, a mistrial could be declared thereafter. The prosecution has violated Kyle Rittenhouse's rights a number of times and done things that are at least dubiously legal. And if the judge decides to throw it out and say mistrial with prejudice, they can't retry him. I think they'd have to go to a federal court or something. They're not going to be able to do anything to Kyle Rittenhouse at that point. That is a possibility. It caused enormous riots. Maybe the judge really is a Trump fan and he's trying to get the leftoids as riled up as possible so that they can show their ass again, and you end up with another Rittenhouse event. Rittenhouse comes out of the court, immediately gets assaulted by Antifa, and more leftoids get shot or something like that. Who knows? Stranger things have happened. That's about all. Peace out.